Wilkerson Law Firm. Today's video is a good one. If you have a criminal defense case, it's one that is probably very important to you. The video today is going to be about bonds. We're going to discuss everything important to know about bonds, and in discussing that, I'm going to attempt to keep this as plain English as possible, and I'm going to minimize the legalese. I promise you. So let's talk a little bit about how to get out of jail, and what happens next after an arrest. Okay. Now, if you or a loved one has been arrested, your first question is a simple one, and it's probably, hey, how do I get out of jail? And it's a great question. Okay. So before we get there, let me give you a quick roadmap. We're going to discuss what bonds are, the types of bonds, logistically, what happens when you obtain a bond, what happens if you don't get a bond, who can hear your bond, or who can hear a bond, who is going to facilitate a bond hearing, and then essentially what your next steps are going to be, whether you secure a bond or you don't. All right. Important to note that, of course, our law firm, Chacon and Wilkerson Law Firm, does handle criminal defense cases. Part of handling your case is going to be addressing a bond. So as we are having this conversation, I'm going to call it a conversation, even though it's very one sided. Feel free to go to the link in our bio. It'll take you to our website. Peruse the website. There's some great blogs in there. Whether you have a family law matter or a criminal defense matter, or you may have both and they just might be intertwined, something like temporary protective order or ex parte hearing that you might have coming up. Take a look at that as we have our discussion. And again, get your notes out, pen and paper. We have some great information for you here that is going to assist you if you have a family member that is going through this process. Okay, so let's go ahead and dive into what is a bond. A bond is essentially a promise, right? It's a promise that you are making to the court, that you are going to return. That promise usually is made in the form of you putting up money or property, right? And there are going to probably be some conditions attached to that bond as well. All right. So it's pretty simple regarding a bond. If you follow the rules, you stay out if you obtain a bond. And of course, if you violate or break those rules, then you know where you're headed. You're coming right on back to jail. All right. Now, let's discuss how and when a bond is going to be decided. If you've listened to some of our other videos, you already know that after you're arrested, within about that 48 to 72-hour time frame, you're going to be standing tall before the man, right? And what I mean by that is you're going to probably be in front of a magistrate court judge, and that judge is going to be notifying you of your charges and whether or not you will receive a bond. It can be decided then and there. Sometimes, depending on the municipality, some of the major, larger cities in the state of Georgia have preset bonds for some types of cases. And so you might already have a bond, just depending on, as soon as you arrive at the jail, depending on the charge. If you don't, then of course you'll go before a magistrate judge. A judge will inform you of your charges, and a judge will let you know whether or not a bond will be granted to you. Okay. And so that all is happening within 48 to 72 hours, again, after and at your initial appearance. And so it's important to know that sometimes you're not granted that bond right away, and your case might be kicked down the road, and you might go before a superior court judge, and that judge will make a decision about whether or not you will receive a bond, right? And so just keep in mind that not every case gets a bond right away, all right? So sometimes people are under the impression that everyone gets a bond, regardless of the charges, regardless of the infraction, and that's just not the case. Okay. All right. So let's discuss the type of bonds since I have you here. The type of bonds, the one that probably everyone is familiar with, is called a signature bond. It's also been known as an OR bond, being released on your own recognizance, right? And so that bond recently, under after the last couple of years, there's new legislation that was signed into law regarding restricting those OR bonds for only certain types of cases. Okay. And so you're not going to see that bond, the OR bond or the signature bond, as often as you used to prior to, I think it was 2024, and I might be wrong about that, so don't quote me. The other is a cash bond, and it's exactly what it sounds like. All right, you're putting up cash, you're paying a full amount of whatever the bond is, and you get that cash back later at a later time. Okay, after of course the party has returned to court, and as long as they of course met all their bond conditions. The third one is the one that most of us are most familiar with. Is going to be a surety bond. Okay, and that is where there's a bondsman involved. Usually in the state of Georgia, you're talking about paying 10 to 15% of that bond, and then the bondsman is going to pick up the rest of those costs. And then finally, number four is going to be the property bond, and that's where you put up a piece of property for your bond in exchange for your bond. And most people use, of course, real estate. And if you have real estate, then you can absolutely use that as a bond as well, as long as you've been granted a bond. Okay. So those are the four types of bond: OR, also known as a signature. You have a cash bond, you have the property bond, and then you have the surety bond using the bondsman. All right. Now, let's discuss what judges look at as they are considering whether or not you are a great candidate for a bond. Okay. And so, if you have pretty serious charges, judges really weigh these factors pretty heavily, right? They're also known as the Ayala factors. I would get into the case. I'm not going to discuss any case law with you today. I promise to keep it simple. And so I will, but just understand that these factors are also known as Ayala factors, right? And so here are three major questions that judges usually ask when it comes to whether or not you're a great candidate for a bond. One is going to be what is your job situation? Obviously, if you are gainfully employed, you're probably looking to continue that employment. You may need money. And so if you're working, then it's probably a good sign that you may return for court at a later time and date. If you have a family, right? You're a family man or woman. You're a mother, you're a dad, you live in a nuclear family, you have children at home. That might make you a great candidate again, because given you will probably come back to court. It's important to judges, it's important to the court that you return on your designated day when your number is called. Okay, and so that's something that judges will take into consideration as well. And then the stability of your life. Do you have a fairly stable life? And if you have a stable life, job, right, family life, home life, there is, again, great determination, determining factor of whether or not you will more than likely return to court. So that is factor one. Will you come back? And that's something that, again, those are just some sub factors that judges will take into consideration. Now let's talk about factor number two. Are you a danger to the community? And that's very important. And it might be more important than factor one. And there is no hierarchy here, but I would probably say this. I would probably put this as number one. Whether or not you are a danger to the community. Okay. And so some of that can be determined by the nature of your charges. If you've been charged with, uh, some kind of serious infraction. Maybe you have committed multiple DUIs. Maybe you've been accused of murder. Maybe you've been accused of doing a drive-by shooting, right, in certain neighborhoods. Those are things that judges have to take into consideration, really about whether or not, if you are released, you are likely to reoffend and be a danger, right, to other citizens in the community. And that again can be decided about the nature of your charges and as well as your past conduct or past behavior, right? So sometimes judges will take a look at your GCIC reports, and well, I will say sometimes the prosecutors might bring that up And of course, it comes up in court, and then it's up to your counsel to essentially come up with some kind of creative arguments to address what's going on with your criminal history. Okay. And then number three, again, this is again leaning on history. What is your history regarding prior cases? So if you have prior cases, right? Let's just say you've been convicted, or you've been previously convicted for arson on multiple occasions, right? And so maybe a judge deems that you might not be a flight risk, but you are a risk to reoffend, right? And so in order to protect the well-being of the community at large, the judge might deem that it's best to keep you detained. Okay, and so these three things are the types of factors that judges take into consideration. Another is whether or not you have missed other court dates. Right, FTAs are basically, it's an acronym for failure to appear. Right, so have you had other court dates that you didn't appear for? You had to be tracked down. All right, they had to put out a bench warrant to come track you down, right, and bring you into court. Okay, haul you in, and if that's the case, then there's a possibility that the judge may not release you, because there is a strong likelihood that you won't come back. Okay, so all of those things are factors, and that's why it's important that if you have these, court dates, that you show up for them, because these are things that judges take into consideration when it's time to consider whether or not you would be a great candidate to be released for bond. All right. Now, so these factors are not about guilt as they are about risk. Okay. And so keep that in mind. A judge is essentially trying to make a determination of whether or not you are not just a risk to the community, but whether or not you are essentially a flight risk, whether or not there is the possibility that you won't return to court on your designated court date. Okay. All right. Now let's talk a little about logistics. Okay. What happens if you get a bond? All right. Step one is that the judge, congratulations, the judge sets a bond along with some conditions for you. Of course, one of the number one conditions is that you don't break any other laws, and we'll talk about that here in a second, about some of the things that we commonly see regarding folks that make mistakes regarding their bond conditions. So the judge sets a bond along with conditions. Also, the bondsman might set conditions as well. Step two, the clerk processes your paperwork. And then step three is you post the bond. And then step four is the step that everybody loves. The jail releases you. Okay. All right. Now, and this usually can take a few hours or longer. Again, depends on the county, depends on where you are locked up. All right. Now let's talk a little bit more about logistics. Okay, so once the jail processes your release, they're going to run their final checks to make sure that you're good. The clerk enters your bond information into the system. The bond company, if you're working with the bond company, they post the bond, they charge their fee, and then sometimes they may require a co-signer as well. And if all goes well, you waltz right through those front doors. Okay. Now, what if you don't get a bond? All right. And hate to be a negative Nancy, but that happens occasionally. Okay. And so if you don't get a bond, as we mentioned earlier, some folks will not. Let's just say that your case is headed to superior court. You're going to go stand before a superior court judge. They're going to consider those Ayala factors I just discussed at your bond hearing. Okay. And so some folks, even after they make it to superior court, they've been denied by the magistrate court judge. They get up to superior and they are denied again. Okay, that happens. So if you are denied, then you will just file another bond motion. Okay, or your counsel will file another bond motion, and they'll schedule another bond hearing. And there, just keep in mind, there can be rounds of this, right? Again, just depending on your history, depending on those Ayala factors, right? Depending on your history, depending on your criminal history, and some of that can be addressed in the GCIC. If hopefully you're not a career criminal, hopefully you haven't appeared before this judge over and over and over again. Hopefully you haven't failed to appear before the judge when you've had your case called in the past. Those things are going to all impact, in addition to how egregious your charges are. Okay. They're going to impact whether or not you receive a bond, right? Now, and this is where essentially having an attorney matters most. Okay. You want to get an attorney involved in this process as early as possible, because they are mindful of how the long game works, right? If you are routinely denied a bond, there might be a problem that is not being addressed. And rather than stay in that loop, you may want to have an attorney on your case, that can kind of tell you what is problematic and what might need to be addressed, in order that you get a bond and get an opportunity to get out and to begin building your defense. Now, one thing that can keep you in jail, even if you get a bond, are holds. Okay, we talk about a little bit about that in another video. So some of the common holds that we see are going to be probation holds. Okay, you've done something wrong, you've crossed probation, there's a hold on you, or there are parole holds. Okay, so sometimes folks have crossed parole and there is a hold placed on them. There are warrant holds. All right, so sometimes you might have a warrant in a different county, all right, a different municipality, and there is a hold on you. And there are immigration holds, okay? And so those things, even if you are granted a bond, they can keep you detained, and it might mean that you're about to take a ride to a different county or even to a different agency, right? To address what's going on with those holds. So you'll see it all the time in these extradition hearings, right? Folks are being sent down the road to address the hold, or they're being sent to a different state to address a hold somewhere else, all right? So a bond does not always mean release, though it usually does, but it doesn't always mean that, right? Getting counsel involved on this is going to be probably in your best interest. Now, we've discussed bonds. Let's discuss why a lawyer matters. And I've kind of started talking about this already. A lawyer can present your case properly, okay, to a judge. They can show your work history, again, the stuff that we discussed a few moments ago, your job history, your family ties in the area. They can show your stability. They can also push for a lower bond, and they can make a creative argument about why it's important that you be released. And so the right argument is important to know this. The right argument can get you home. This is important, guys, because this is where folks make mistakes. Telling the judge that you have kids at home that depend on you, and that are relying on you, and that if it's a holiday coming up, we sometimes get clients say, "Hey, Your Honor, I just want to be home for Christmas." These are not persuasive arguments, guys. These are not persuasive arguments. And so many times, your attorney, your counsel, who has appeared before these judges, more than likely, especially if they're local, on a number of occasions, know what the judges like to hear. All right, when it comes to obtaining a bond. So it's always in your best interest to get some good counsel in front of this, and to have them address not just bond, but of course your case. And so if you are pro se, it's something that you really strongly want to think about. Now, there is why being out on bond is helpful. Bond decisions affect really your entire case, right? So being out on bond is helpful for a myriad of reasons. One is you are able to work, okay? And so being able to work is important for all the reasons that you're able to make money, okay? And that's going to help you maybe secure a defense attorney. It's going to help you pay bills and keep from being evicted, and losing your car and whatever other property that you might have. All right. So being out, being able to work is essential. It allows you to meet with your attorney. That's super important, guys. Being able to sit down and meet with your attorney, and discuss strategy. That's going to be important, to building a strong defense in your case. And then again, building that defense in your case from being on the outside, you can get things to your attorney, things like evidence, helping assist your attorney with strategy where that might be helpful. And on the outside, right? Come to office hours, sit with your counsel, and address their questions to help you build a strong defense. And those are obvious benefits. Those are just some of the benefits, I should say, of being out. Some of these facilities, are the living conditions are less than optimal. I won't name names. If you've gone through this process, you know what I'm talking about. If you're in Clayton County, you're in Fulton County, you're in Bibb County, you know exactly what I'm talking about, right? So, good idea to be home as opposed to in some of these facilities and the lockups. All right. Now, I talked a little bit about some of the common mistakes that we usually see, and here they are. All right. Clients talking too much in court. So I see this a lot in initial appearances. Folks pop up in front of the judge and they spill their guts, right? They discuss everything, will say everything, that they believe the judge wants to hear, in order to try to get out of detention. An initial appearance, that's not the purpose of an initial appearance. The judge is going to ask you, to kind of button it up. Your counsel is going to ask you to put your two lips together and stop talking, because essentially if there is a prosecutor present or someone from the district attorney's office, and they are listening in, there are a lot of things that you probably don't want to say, that are being recorded, okay, and that are ultimately going to be unhelpful, in really adjudicating your case, okay. And so you want to be mindful that an initial appearance or at a bond hearing, there are just certain things I've seen people give admissions, whole admissions, destroy their cases, at initial appearance or at bond hearings. So you want to take the counsel of your attorney. These folks went to law school. They put in a lot of hours. Many of them, especially because I've worked at the Bibb County Public Defender's Office, many of them are very passionate, about the work that they do. They're very professional. And so you want to be mindful of what your counsel is sharing with you. If they're telling you to kind of button it up, you might want to listen. They're probably telling you that for a reason. Okay. And so that's number one, is clients talking too much, getting on those jail phones, and again, oversharing about your case, is another thing that we see that either A, lands clients back in jail, or B, they end up, really being, those conversations being used as exhibit A, B, C, D, and E, in their case, right? Because they're talking about things, that they shouldn't be discussing with family members, or they're reaching out to parties that the judges have said not to contact, right? So if there's been a no contact order, with, let's just say an ex-girlfriend, and you get on the jail phone, and guess what? You call the ex-girlfriend, right? Judge told you not to do it, right? And so it's played in court, it destroys your case, right? Destroys your defense, right? And so anything that might have been on the table comes off. Now your case looks like a slam dunk to a prosecutor, right? So it makes it a lot harder to defend, if you are openly violating a court's orders, right? And so those jail phones are big mistakes that we see clients make, in oversharing, or contacting people they're not supposed to contact. And then after release, people just violating bond conditions, is another common mistake that we see. Folks are released, they get the bond, we worked really hard to get them a bond. They get out there and they just violate the conditions, right? They're told not to break any more laws. They break laws. They're contacting victims. They are essentially, trying to dissuade folks from, essentially testifying, whatever the case might be. And it destroys their credibility, hurts their case. Just you just raise in terms of providing a competent defense, you've raised the difficulty level for your counsel, for your attorney, all right? And you just basically provided all this new evidence against you for the prosecution. So, again, difficulty levels raised for your defense, and it's been lowered for the prosecution, makes it a lot easier to prosecute your case. And then lastly, clients just waiting too long to hire an attorney, bringing an attorney on in the 11th hour, right? After a lot of mistakes have been made, it's very hard once you've kind of started digging your grave to really fix it, right? So it's like bringing on a carpenter after to put on a roof after you've built a very bad foundation in a very bad home, right? It's gonna fall down. Doesn't really make a difference how great the work the carpenter does on the roof, right? And so, it's always great to have an attorney on your case as early as possible. All right. So just keep in mind that most mistakes in these cases they happen early. So get that counsel involved as soon as you can. All right. Quick roadmap for you to keep in mind. All right, so that you don't get too frustrated with this process. If you do find yourself being arrested, the arrest, the initial appearance, God willing, you get the bond, is granted, you go home. The bond is denied, that's fine. You motion for another bond, and you get a bond hearing, and God willing, you go home. Okay. So that's the roadmap. All right. So you won't panic if you're ever arrested. You know what's to come. All right. Now, if you or a loved one is going through a criminal case, you have a criminal case, you've been arrested, you need defense, feel free to give us a call, 404 999 9529 or 478 845 1213. We represent you in felony cases. We can also help you out in misdemeanor cases. It's best to get us involved as soon as possible. Okay. It's best to have an attorney involved as soon as possible. All right. And as a final word, your first win in a criminal case is getting out of jail. All right, that's your first victory for all the reasons I just discussed. And that starts with a very strong bond strategy. All right, guys, my name is Genghis Shakan here at Shakan and Wilkerson Law Firm. On behalf of myself and Chelsea Wilkerson, thank you for watching. We have other videos. Make sure you like, follow, and if you have a friend or a family member that is going through a case or they've recently been arrested, make sure you share this video with them. Okay. It's important, especially if they're here in the state of Georgia. It's important that they know what to expect and follow this roadmap that we discussed and that I shared with you previously. All right. It has been a blessing speaking with you. We'll see you on the next video, guys.